Sylvia Idowu. Thanks for joining me on Handy Law. I want us to look at our fundamental human rights. The history of human rights as a provision under the laws of any nation started with the Universal Declaration of Human Rights. This was a document drafted by representatives with different legal and cultural backgrounds from all regions of the world. It was proclaimed by the United Nations General Assembly in Paris on December 10, 1948. It set out for the first time fundamental human rights to be universally protected. Over the years, this has translated to different kinds of legal arrangements, whether in the form of treaties, regional agreements, or domestic law, through which human rights are expressed and guaranteed. Nigeria, as a member nation, has adopted various aspects of these rights into her domestic law. The fundamental human rights that we will look at in this series will be taken from the 1999 Constitution of the Federal Republic of Nigeria. Today, we will look at the first provision and continue in subsequent series to take other provisions as time may permit. While some of us know our rights, others do not, so let's find out. The first provision talks about the right to life, yours and mine. That's actually found in section 33 of the Constitution. It says, no one shall be deprived intentionally of his right to life. This is why one person cannot decide to take the life of another person, because that will be depriving that other person of his right to life. Usually, the full force of the law will be brought to bear against anyone who does this. However, there are times when the Constitution considers the taking of life as not contravening the provisions of this section. One of those times is in the execution of the sentence of the court in respect of a criminal offense in which a person has been found guilty of in Nigeria. In other words, if someone is convicted of a crime that carries death penalty, the execution of such penalty will not be seen as contravening the provisions of this section. Secondly, a person shall not be regarded as having been intentionally deprived of his life if he dies as a result of the use of what the Constitution calls reasonable force and in circumstances permitted by law to stop such a person from committing acts such as violence against another person, destruction of other people's properties, escaping lawful arrest or detention, or to stop riots, insurrection and mutiny, and so forth. It's up to the law courts, however, to determine whether reasonable or excessive force was used in each case. Then we have what is called Acts of the National Assembly. To fast forward to section 45, which addresses the provision in section 33 here, the right to life. To paraphrase, it says, Acts of the National Assembly in a period of emergency, which is reasonably justifiable, will not be regarded as contravening the provisions of section 33. Let's assume Nigeria is at war, and the authorities are forced to conscript people to go to war. Death occurring here will be deemed simply as death resulting from an act of war. So we have come to the end of this particular segment. See you next time when we will look at other aspects of our fundamental human rights. If you found this session helpful, leave a comment. Also, don't forget to like and hit the subscribe button.